I'm David Sobel. I'm a real estate and finance attorney here in Michigan. You know, it never ceases to amaze me when somebody engaging in a real estate transaction or a loan agreement, they'd prefer to write up their own documents without the benefit of a licensed and experienced real estate attorney. Instead, what they're willing to do is they'll buy a building, they'll buy a home, they'll lease a retail space, or even buy into a business for hundreds and thousands of dollars. But they refuse or they won't take the time to sit with an attorney to draft their real estate purchase agreement or their loan agreement or their business agreement. And really they're doing so with, at their own peril. So, I have a great example that recently I experienced, and it relates to a business owner who was expanding his storefront. And he and his contractor got into a dispute related to the quality of the workmanship that was performed. And both parties ended up going to court, and the contract they drafted had actually not one, but two provisions dealing with attorney fees. So they did this on their own, and most contracts, just so you know, only have one provision that addresses attorney fees. That's what's normal, one provision. But in this case, both parties were actually feeling very generous, and they inserted two provisions. So the first provision that addressed attorney fees, and that basically means who gets the attorney fees in the event that they win a lawsuit. Does the loser pay? That's kind of what the attorney fee provision would mean. So in this situation, the attorney fee provision basically said that only a prevailing party could collect attorney fees. So the judge said that in order for either party to have prevailed, they would have had to be right on all counts in the lawsuit. So seeing that this was just a typical lawsuit, both parties were right, but not on all issues. So no attorney fees were actually awarded under that provision. But the problem became that maybe both parties won under this provision. They won the battle, but they didn't win the war. Neither party had to pay the other party the attorney fees under that provision. But there was another provision, if you recall, that they had inserted, because again, they put two provisions in their contract. So the second provision was kind of ridiculous. And basically, in the contract that they wrote up, it said that whoever brought the legal action was entitled to his attorney fees. Again, not only is this ridiculous, but what it really does is it awards one party for actually bringing the lawsuit first. And the court actually decided to read this literally. And it didn't matter if either client was right or wrong, or either party was right or wrong. Whoever brought the action first was awarded their attorney fees. So with this type of provision, there's always going to be a loser because the provision encourages, again, bringing a lawsuit. So that provision cost one of the parties mid $30,000 to $40,000 in attorney fees, which is really unfortunate. So remember, contracts have many provisions. And if you forget to go to an attorney, if you forget that you're going to write this contract and you don't put in the right provisions, or you fail to recognize the nuances in the contract language, it could cost you. Take that example as a warning. You're going to thank me later. So I'm David Sobel. If you need to reach me, my number is 888-789-1715, real estate and finance.